The jury is now considering whether to convict Donald Trump on 34 felony counts of falsification of business records. It would be a shock, frankly, if he were not convicted in this particular case, because, of course, he's got 12 angry New Yorkers on the jury. And New York juries probably not going to be particularly fond of President Trump. Also, the judge in this case has made it a foregone conclusion that Trump will be convicted. The reason I say that is because his jury instructions are totally insane. So last night, the jury got the case. They got about 11:30 a.m. Eastern time. They deliberated for like 4.5 hours, and then they went out for a hoagie or something. And they are back this morning, still deliberating. Just before 4 p.m., according to the Wall Street Journal, jurors asked to, again, hear legal instructions the judge had read earlier in the day, because this is a very confusing legal case, mainly because no one knows what the hell the charges are. So I have the jury instructions here in front of me. The problem with the jury instructions is that it is absolutely unclear what exactly the crime that is being alleged is. It's a two-part crime. The first crime would be falsifying business records in the first degree under New York Penal Law, Section 175.10. That law says that a person is guilty of falsifying business records in the first degree when, with intent to defraud, that includes an intent to commit another crime or to aid or conceal the commission thereof, that person makes or causes a false entry in the business records of an enterprise. So the idea here would be that if Donald Trump made a false business record in 2017 with intent to cover up a crime in 2016, that's what falsifying business records in the first degree would be. The problem is, what was the second crime that he was seeking to cover up? And the answer is, The big problem with this case, of course, is that Alvin Bragg is trying to spin a non-existent crime out of Donald Trump making a hush money payment. Now, hush money payments are ugly, and they're unseemly, and they're kind of gross, particularly when you're talking about paying somebody off to shut up about one 10-minute stand that you had in like 2007 at a golf tournament with a porn star. Like that's awkward, but that doesn't make it illegal. Not under federal law, not under New York state law. So what is the second crime? That's really the issue here, because falsifying business records is a misdemeanor. What turns it into a felony is the underlying crime that you are seeking to supposedly cover up. And here is where the jury instructions get super duper weird. So according to the jury instructions that Judge Juan Merchan gave to the jury yesterday, quote, the people allege that the other crime the defendant intended to commit, aid or conceal, is a violation of New York election law section 17152. Section 17152 of the New York election law provides that any two or more persons who conspire to promote or prevent the election of any person to a public office by unlawful means, and which conspiracy is acted upon by one or more of the parties thereto, shall be guilty of conspiracy to promote or prevent an election. Under our law, when a person is guilty of such conspiracy with intent that conduct be performed that would promote or prevent the election of a person by unlawful means. Okay, so what is the unlawful means? Again, a hush money payment is not necessarily unlawful means. People do all sorts of things to impact elections. They go on the campaign stump and they fib. They activate their agents to try to bury stories from, there's all sorts of stuff that's ugly in elections. We've known about it for literally thousands of years, that people do in order to affect the outcome of elections. The question is whether the thing you are doing is illegal, such that falsifying a business records about that thing turns it into a felony. So what does unlawful means mean? According to Judge Merchan, this is where it gets super weird. He says that there are three possibilities of unlawful means being used in order to impact the 2016 election. Unlawful means, number one, violations of the Federal Election Campaign Act, otherwise known as FECA. 2, the falsification of other business records. Or 3, violation of tax laws. Now, what's particularly weird about this, what's super weird about this, is that Merchan says, quote, although you must conclude unanimously that the defendant conspired to promote or prevent the election of any person to a public office by unlawful means, you need not be unanimous as to what those unlawful means were. That is something I've never heard of anything remotely like that in criminal law before. That I'm going to specify 3 possible crimes. The jury can disagree on which of those 3 crimes were committed. But if you have a unanimous verdict that a crime was committed, then you can be convicted under the second law. That's super strange. So to take a sort of strained analogy, legally speaking, there is a crime called felony murder. Felony murder is where a felony is committed, and in the middle of that felony, a murder happens by a member of your gang. So let's say your gang is holding up a bank. So the robbery of the bank, the armed robbery, is a felony. And let's say that a member of your crew murders someone in the commission of that armed robbery. It's not you. A member of your crew does it. You can still be charged with felony murder because the idea is that the murder arose from the armed robbery. Okay, so it's the secondary crime that becomes the primary crime, sort of. Now imagine that it weren't armed robbery. There were like a bevy of different crimes that were alleged but not necessarily proved. Could you actually convict somebody of felony murder, for example, without specifying unanimously what the felony was? There were like 3 different felonies that were possible. One was like tax evasion. One was armed robbery. And one was some form of wife beating, assault, sexual assault. And we don't know which one of those it was. But if 4 of you agree on one and 4 of you agree on another and 4 of you agree on the third, and a murder was committed by somebody in your crew attendant to any one of those 3, then we'll convict you. I've never heard of anything remotely like this. It's super strange. It's relatively unprecedented legally so far as I'm aware. Beyond which, all of the allegations here, the 3 laws that are sort of underlying the misdemeanor. Again, remember, there's a patina of a misdemeanor, which is violation of New York election law. And it's supposed to stack on top of some other sort of concealed crime. And there are 3 types of crime that are being alleged that the jury does not have to be unanimous upon, according to Judge Merritt. First of all, I don't see how this is reversible error. Those jury instructions are so bizarre. I don't see how this doesn't get reversed on appeal. But here are the 3 possibilities. The Federal Election Campaign Act. The first of the people's theories of unlawful means, which I will now define for you, is the Federal Election Campaign Act. Under FECA, it is unlawful for an individual to willfully make a contribution to any candidate with respect to any election for a federal office, including the office of the presidency, which exceeds a certain limit. In 2015 and 2016, that limit was $2,700. It is also unlawful under FECA for any corporation to willfully make a contribution of any amount to a candidate or candidate's campaign in connection with any federal election or for any person to cause such a corporate contribution. We'll get to more on this in just 1 second. First, do you know what's dumb? The Biden campaign thinking Robert De Niro is like a great idea and is still relevant. Do you know what else is dumb? Not having life insurance. Getting life insurance will give you peace of mind knowing that if something were to happen to you, your family could cover expenses while getting back on their feet. Policy Genius has licensed award-winning agents and technology that make it easy to compare life insurance quotes from America's top insurers in just a few clicks to find the lowest price. Their team of licensed experts is on hand to help you through the process. Even if you already have a life insurance policy through work, it may not offer enough protection for your family's needs. It might not follow you if you leave your job. You have to be prepared for the worst possible contingencies. Life insurance does that. It's why we have life insurance. With Policy Genius, you can find life insurance policies starting at just $292 per year for $1 million in coverage. Some options offer same-day approval and avoid those unnecessary medical exams. Policy Genius works for you, not the insurance companies, which means they don't have the incentive to recommend one insurer over another. Save time, save money, provide your family with a financial safety net using Policy Genius. Head on over to policygenius.com/Shapiro to get your free life insurance quotes. See how much you could save. That's policygenius.com/Shapiro, policygenius.com/Shapiro. So the basic idea here would be that Donald Trump, in making a payoff via Michael Cohen to David Pecker at the National Enquirer to pay off Stormy Daniels, that was, in fact, a campaign contribution that was not labeled as such and therefore was a federal campaign finance violation. The problem, of course, is the federal government looked at this and didn't do anything about it. So what you have is a state prosecutor attempting to spin a non-existent federal felony into a state-level felony for purposes of prosecution. By the way, there's literally no evidence that Donald Trump was falsifying business records in 2017 in order to cover up anything having to do with FECA. See, one of the problems with this entire case is that you have to prove Donald Trump's legal intent to defy the law by signing certain things. And Donald Trump's entire case has basically been, well, Michael Cohen was my lawyer. He's the one who's supposed to do it legally. So I told him to go do it legally, and if he did it illegally, that's his problem. Which, in a specific intent case, which this is, a willful intent case, that's what the law says, not a horrible defense. I mean, by the way, most of us do this with our lawyers all the time. I'm a lawyer, and I still do this with my lawyers. I say to them, do what you have to do to make sure that I'm complying with all available law. Now, if they then advise me badly and they go and violate the law on my behalf, can I be held responsible for my lawyers being bad lawyers? That's essentially Trump's contention. The second possibility is falsification of other business records. So it's turtles all the way down under this one. Under New York law, a person is guilty of falsifying business records in the second degree when, with intent to defraud, he or she makes or causes a false entry in the business records of an enterprise. For purposes of determining whether falsifying business records in the second degree was an unlawful means used by a conspiracy to promote or prevent an election, you may consider the bank records associated with Michael Cohen's account formation paperwork, blah, blah, blah. So basically, this is still a FECA violation, right? What they're basically saying is that there was a falsification of state-level business records in order to illegally pay off Stormy Daniels, but they've not proved that she was illegally paid off. Again, she was paid off, almost certainly, but illegally, not clear at all. And finally, violation of tax laws. It is unlawful under New York State and New York City law to knowingly submit or submit materially false or fraudulent information in connection with any tax return. Now, again, this is really, really weak tea. And it becomes even weaker to you when you recognize that what the judge is doing here is cobbling together a basic series of legal excuses and then saying to the jury, choose from this Chinese menu of possible legal excuses, and if you can come to unanimity that you want anything on this Chinese menu, Donald Trump is guilty. So Andy McCarthy, the legal analyst over at National Review, he has a good piece explaining the problem here. He says, with the help of Judge Juan Merchan and none other than Donald Trump, prosecutors from the Office of Elected Progressive Democratic District Attorney Alvin Bragg have effectively concealed what should have been fatal holes in their case. The state is well aware of these holes and has thus cleverly created an illusion of mountainous evidence. The sleight of hand is that the mountain proves legal conduct. It seems illegal because the subject matter is sordid, paying off a porn star and a Playboy model during the 2016 election to maintain silence about extramarital affairs with Trump. But the payoffs were lawful consideration for lawful contracts. It is not hard for prosecutors to assemble prodigious proof of legal acts, even unsavory ones. The hope is that no one will notice the dearth of proof on what is the dispositive issue. In 2016 and 2017, when these non-disclosure agreements between the National Enquirer and Stormy Daniels and Karen McDougal were being negotiated, and then Trump reimbursed fixer Michael Cohen for the Stormy payoff, did Trump willfully violate the federal campaign finance laws, which prescribe felony offenses Bragg has no jurisdiction to enforce? And as Andy McCarthy says, there is not a shred of evidence that Trump was even thinking about FICA in 2016, 2017, much less willfully transgressing it. With Merchan's help and not much resistance from defense lawyers, Bragg seemed to shrewdly conflated two very different things. One, knowing and intentionally burying politically damaging information through NDAs, which is in fact legal. And two, knowing and intentional flouting FICA regulations, which would be illegal if prosecutors could prove it, but there's no evidence against Trump. So he says, obviously, this case is lacking on the merits. One problem here is that Donald Trump, because he has insisted politically that he never slept with Stormy Daniels or Karen McDougal or any of the rest of this sort of stuff, because he says that sort of stuff, it makes it difficult to defend his case legally, which is true. Right? As Andy McCarthy points out, he says, Team Trump has presented one of the most ill-conceived, self-destructive defenses I've ever seen in decades of trying and analyzing criminal cases. The reason is clear. Trump insisted his lawyers subordinate his defense at trial to the political narrative he wants to spin in the 2024 campaign. Against the weight of evidence and common sense, Trump insists on telling voters that Stormy Daniels and Karen McDougal are lying. But no one with even a passing familiarity with Trump's combative and parsimonious nature would believe for a second he would agree to pay $130,000 to Stormy and $150,000 to McDougal if they were falsely claiming to have had affairs with him. Or that Cohen would have paid Stormy and Trump's pal David Pecker would have paid McDougal unless Trump had greenlit the payments and assured them of repayment. Legally speaking, says McCarthy, Trump's gambit is disastrous. It makes no sense in a criminal courtroom for a defendant to deny his complicity in legal conduct when there's daunting evidence he was complicit up to the neck. So basically, what McCarthy is saying is that the prosecutors are trying to prove effectively that Trump engaged in ugly but legal conduct. And Trump is saying, I didn't even engage in the ugly conduct, when what he's saying is, sure, it's ugly, but also it was totally legal. Right? That's the argument that Trump should be making, but he's not making that particular argument. Now, maybe that makes no difference. Maybe that makes no difference because, again, the jury is oriented against him, and Merchan clearly wants some sort of conviction here. And as McCarthy says, none of this would matter if the jury understood that, first, paying NDAs is not a campaign expenditure under FICA that triggers spending limits and reporting requirements, and B, there's no evidence that Trump or even Cohen or Pecker were thinking about FICA, much less conspiring to flout it when the NDAs were paid and when Cohen was reimbursed. FICA was not an issue until the FEC started asking questions in early 2018, long after the NDAs were negotiated, and weeks after the last reimbursement payment to Cohen. It is not possible to prove beyond a reasonable doubt Trump willfully intended to violate FICA if there's no indication he ever thought about it at the relevant time. So again, this basically is a conspiracy between the judge and the prosecutors to find Trump guilty of a crime that doesn't exist. He says the judge and prosecutors have led jurors to believe the violation of FICA is an established fact in this case. But that's not right.